Yes, that sounds good. Dan, you want to log in and make sure you're there?
Yep, I'm here and can hear everybody loud and clear.
Okay, great. Obviously, I'm Mark Shear, and it's my pleasure to be the moderator for today's Themis Advocates Group seminar webinar on unanchored and untethered verdicts. We've collected an amazing group of talented people here to talk about this with us. And I'm just very thankful for the speakers to volunteer their time on this important topic and give us some of their wisdom and experience and advice on this incredibly important topic. It's a hot topic these days. Before I get into introducing the speakers, I got a couple of housekeeping items. Also, I wanted to make sure I thank Lindsay Strange from Themis for all of her help in setting this up and getting this going and making sure the links are good. Really couldn't have done it without her. Also, Lindsay was able to get this seminar qualified for CLE and CE credit. So anybody that needs continuing education credits or legal credits is able to get those credits. And Lindsay would be able to assist you if you needed some help with that on the application for the CLE credits for your own state. Plus, if you got the registration email that went out for this to dial into the seminar, you should be able to use that to support the fact that you attended and what it was. We had a number of requests from people that wanted to attend but couldn't make it on today. So Lindsay has arranged to have this videotaped, and the videotape will be available online sometime probably by the end of the week or next week. Actually, it's almost the end of the week now, but I am told that it's going to be on YouTube. So we're all going to be YouTube stars. I'm pretty excited about telling my teenage son that. I'm not sure he's going to be convinced that I'm an influencer, but what the heck. So we'll be on YouTube and we can get you the link. If you need that to distribute to your people in your company or otherwise, you can reach out to Lindsay Strange, or you can also email me or any of the speakers. My email is just very easy. It's just mark@shear.law. Make sure you got a C in the Shear, but mark@shear.law, and we can get you that link. It won't be up for a day or two, but we will have that. One other thing before I introduce the speakers, we're going to have some polling questions today. That's one of the things we have to do to qualify for the CE credits and CLE credits. So we'll put those up from time to time, and you'll have a chance. I think on Zoom there's a polling button where you can answer yes or no or respond to our polling questions. Let me start off by telling you who's going to speak and what their topic's going to be on. Elizabeth Sharrock, you can see her on the screen, is a partner at Rhodes, Hieronymus, Jones, Tucker, and Gable, and she's in Oklahoma, but she actually grew up in Alaska, and she completed her undergraduate studies at the University of Oklahoma, and she stayed there to get her law degree in 1997. She's an AV preeminent rated litigator and was recognized in 2008 through 2011 as a rising star in Oklahoma Magazine's Super Lawyer Edition, and a 2017 Best Lawyer in America inductee, no surprise there. One of the little things that you wouldn't know about Elizabeth, let me share with you, is that she was one of the original brief writers for the prosecution of Terry Nichols in the Oklahoma County DA's office. You remember the Oklahoma City bombing case from years ago. If you're old enough like me and George, you remember that. Elizabeth was right there front line. And she also serves on the board of a local off-the-track thoroughbred equine sanctuary and has 3 horses of her own, affectionately known as the 3 bad boys. So I'll leave it to Elizabeth to work that into her presentation somehow. Elizabeth's going to talk about the national trend. One of the things we want to make sure we got to you in this seminar is that you would have the ability to know what some of the arguments that are being made about this topic in other jurisdictions. And I'm going to go through a few examples before I turn it over to Elizabeth, but she's going to do a short national survey that gives us some information about that. So that should be very helpful and informative. George Pappas is going to speak after Elizabeth, or actually before Elizabeth. George, probably everybody on this knows George already. If you have anything to do with Themis at all, you know George, and he's or if you've ever even been close to Texas, he's a pretty big personality. And just delighted that George is going to be sharing some of his personal experiences on this. George has a couple of case examples, so that should be very helpful. He's actually had a few trials with this issue that's come up. And I'm not going to go through George's background because he's got too many accolades. It'd take us too long. We'd burn up the whole hour. But I will tell you this. He just finished a recent jury trial where the jury awarded $0 for past and future pain and suffering. I don't think it was a defense verdict. Otherwise, he would have said that. So I'll let him fill in on the details. And in the category of did you know, I got two great factoids about George. And you would have to know him really well to know either one of these. Number one is he's doing this seminar from the waiting room at the airport in Cancun, Mexico. No kidding, Scout's honor. All right. George's flight was delayed or canceled or something like that. And thank God he's still here. You'd have to listen to me this whole time. But George is going to talk about his cases. And the other factoid, and I love this one because we're going to have to follow up with this. Did you know that George Pappas was an extra in the background of the Urban Cowboy Dance Contest? That's the one with John Travolta. And it's on, he actually is on YouTube already. There's a video out there of this. He says he's in it. But I figure we're probably going to be lucky to get him to talk about it, or sometime, maybe at the annual meeting, we'll get George to bust out a move and show us some of that dance.
I was only about half the size then as I am now.
All right, last but certainly not least, Daniel Wolf has joined us. Daniel is the Senior Director of Jury Consulting at Magna Legal Services. Obviously, most of you are probably familiar with Magna, but they're a nationwide full-service litigation consulting and strategic communications firm. I've used Magna. I'll give a personal attestation. I've used Magna several times now for mock juries and jury consulting. Excellent work, excellent job. Love working with them, both online and in person, by the way. Dan's been a jury consultant and researcher since 1986, which is when I was admitted to the practice of law. That's a damn long time ago, Dan. And he's been in the national spotlight a few times, numerous times, on high-profile criminal and civil cases involving celebrities and professional athletes. And he's been a commentator on national and local TV shows and talk shows and radios. I mean, again, his resume goes on for ever and ever. He's worked on over 1,800 cases. He's got a JD and a PhD in law and psychology and an MA in psychology from the University of Nebraska. BA in psychology and sociology from Colorado. So he's kind of bounced around a couple different states. And I am really excited to hear Dan's presentation. I haven't heard it yet, but one of the reasons I'm particularly excited to hear Dan speak is he's going to talk, like I said, about the psychology of this untethered verdict. This is definitely a psychological approach that the plaintiff bar is using. And I think it's been very effective by some results we've seen. So Dan's going to share some of his experience and some of his information about that, and we'll see where it takes us. All right, Lindsay, why don't you put that first polling question up there so we can get some audience participation and response. There it is, folks. Do you think plaintiff cases that are conducted after waiving special damages, such as medical specials, result in higher verdicts? Yes or no? So you guys, I don't know how to do it, but oh, it says the host and panelists cannot vote, so I don't even get a vote. I'll repeat the question again. Do you think plaintiff cases that are conducted after waiving special damages, such as medical specials, result in higher verdicts? Yes or no? And it's a pretty general polling question. I'm going to talk right over the top of that unless Lindsay tells me I can't do that, and continue on with the presentation. Before I get to Elizabeth's presentation and George's presentation, I want to talk about a few things of the seminar. The first is I want to define anchoring, or what we mean when we say an untethered or unanchored verdict. How does it work? Why is this a trend? Ironically, I was talking to somebody today that handles cases nationally, and they really didn't know about it. And I thought that everybody was kind of aware of this, but it's not. Unanchored and untethered, for the purposes of our conversation today, untethered or unanchored means when the plaintiff comes into a case, and often they'll do it the day before trial or the day of trial, and they say, guess what, we're waiving our special damages. We're not going to blackboard any medicals. We're not going to blackboard any past wage loss, usually because there aren't very many or it's low by comparison. And oftentimes the reason they do this is they don't want that number as an anchor or a tether. If they come in, I'll give you a recent case example that I have. It was a pretty bad injury, but it didn't result in very much medical specials, probably less than 50,000. And it did result in a permanent impairment of the gentleman's left leg. He was going to have a limp and some pain, and it was untreatable. There's no question about that. And plaintiff told us ahead of time, plaintiff counsel, who has done this before on multiple other cases with success, told us he was going to come in and ask the jury for $20 million, $20 million. Okay, this is on a case where the overall total body disability rating probably was less than 10%, but he did have a limp and it was going to have pain. It's untreatable. He's going to have it for the rest of his life, and his medical specials were really low. It didn't go to verdict because we had some motions practice and we won on a big motion, and they took a nominal offer for us, a settlement offer we had out there. So we got done with that. But the point is, if they had gone that way, and I've had several cases where the plaintiff attorney has done this, where they've waived special damages. But if that happens, what do? What happens with the plaintiff side is they waive the special damages, and then they ask for an extraordinarily high number. And say in my case example, where the plaintiff attorney said he was going to ask for 20 million, even if the jury only gives him 5 million, that's a huge result. And how do you come back on the defense and say, hey, it's 200,000, not 20 million? You're going to look like you're really cheap or really ridiculous, or you could. Two other examples I want to give you, not my cases, but recent cases in my jurisdiction. I was actually involved in the Crane case I'll tell you about in a tangential way, but I'm not going to reveal much about it because it's all confidential. But in that case, the plaintiff attorney asked the jury for $250 million for 3 wrongful deaths, or excuse me, 1 wrongful death and 2 injury cases. The jury came back with $150 million. $150 million verdict. It's been in the news. It was all over, published all over the place because it was such a high verdict. He asked for $250 million. He only gets $150 million. $72 million of that was for 1 wrongful death plaintiff, which is probably a record in Washington. That simply typically doesn't happen. Really good plaintiff attorney, but really good defense attorney too. And this was an untethered or unanchored approach. It didn't blackboard any specials. No wage loss, no medicals, and that's the kind of verdict they got. The second one I want to tell you about is called the Ride the Duck case. This was a few years ago. You might have read about it. There's been a couple of them. It's where that amphibious vehicle takes tourists around town and then it goes into water. In our case, in Washington, Seattle, there's a Ride the Duck program or tourist attraction. It got in a head-on collision on a bridge. 41 passengers, some of them were hurt very, very bad, and some were not hurt at all. At the last minute in that trial, again, we weren't involved in that one, but I know about it from people that were trying it and involved, and from the verdict result. In that case, the plaintiff attorney waived all of the medical specials of the plaintiffs at the very last minute. The defense attorneys weren't accustomed to this, weren't aware of this approach, and didn't have a response to it. And then she went into closing and just asked the jury to give $4 million each to each plaintiff. Let's just make it easy, $4 million for each plaintiff. And the jury came back and did exactly that. That's how you get to a $120+ million verdict. You just average it across all of your plaintiffs, and everybody got the same amount. Actually, I think it was 34 plaintiffs, something like that. But again, outsized monster verdict. Now, here's where I want to define something else, though. When I say an untethered, unanchored verdict, that is not a nuclear verdict. That's a subset of nuclear verdicts. I think Dan's going to talk about this. Nuclear verdicts, we're all seeing those where you get some runaway, ridiculous result, massive verdict by a jury. Those are nuclear. A certain portion of those nuclear verdicts are untethered or unanchored, like I'm talking about. What is anchoring? I'll talk about it real quick too, but I'll leave most of this to Dan. Anchoring bias is a cognitive bias. This is a technical description of it that I pulled off the internet. Anchoring bias is a cognitive bias that causes us to rely too heavily on the first piece of information we're given about a topic. That's the kind of the general idea. Let me give you a real practical example. Actually, let me use George since he's in Cancun. Yesterday, George walks down the street in Cancun and one of these tourist vendors says, "Hey, George, you're a good looking guy. You'd look better with this t-shirt. This t-shirt costs $1,200. And George goes, $1,200? Are you kidding me? I'm not paying $1,200 for a t-shirt. I'm a Gucci guy, but I'm not paying $1,200 for a t-shirt. George walks down one more block and another vendor has a t-shirt. And George says, well, that's a good looking t-shirt. How much is that t-shirt? And the vendor goes, $100, senor. And George says, that doesn't sound too bad, $100. Okay, the only reason $100 sounds reasonable is because the one he just talked to before said $1,200. $100 for a t-shirt. I don't know, maybe George does pay that kind of money for t-shirts, but $100 for a t-shirt is outrageous. That's the concept of anchoring bias. It's a faulty heuristic which occurs when you focus on one piece of information at the expense of other information that might be relevant or relative. Okay, so I've defined it. I've given you an idea of what it is. Of course, most of you attending probably know, or you wouldn't be here to begin with. How do you break the anchoring bias? You need to understand it, obviously. So we're going to talk about case law across the country. Before we do that, though, George, would you lead us off and give us some of your examples? And before you do that, everybody that's participating and attending virtually, if you want to shoot a question to us, we're going to have Q&A at the end of the seminar too. But if you have a question during the process, go ahead and shoot it to us. We're monitoring those. Dan and I are taking a look at those and we'll try to respond to them either live or during the presentations. But George, I'm going to hand it over to you. Tell us about your case examples.
Sure, Mark. Thank you very much. And ladies and gentlemen, I can't see y'all, but thank y'all for participating. I have two cases that I've recently tried that deal with this topic. The first is back in October in Harris County, Houston, with a very skilled and talented plaintiff's lawyer on the other side. The case was a case of clear liability. My driver was clearly at fault in the accident. The plaintiff was in her late 50s, early 60s, had a pretty serious elbow injury for which she had 4 different surgeries. And while she was not able to be cured, quote unquote, she would always have some lasting disability. The medicals, because she made her claim on health insurance, were relatively minimal. In fact, I think her paid and incurred medical was $50,000. She was a low wage earner. Her past wage loss was, again, on the order of 50. And because of her age, probably had a future loss of earning capacity model of a couple of $100,000. Before trial, and well before trial, it wasn't a surprise. The plaintiff submitted their claim to drop any claim for past or future medical or past or future wage loss or loss of earning capacity. This was the first case that I tried post-COVID. Jury selection was actually in the arena where next door to the stadium where the Texans play. A lot of social distancing going on, a lot of masks. It was pretty awkward. But the interesting thing that came of it was that the plaintiff's lawyer, first words out of his mouth in voir dire was, ladies and gentlemen, we're here to compensate this woman for her injuries. And we are going to ask you for $7 to $8 million in pain, suffering, and mental anguish. And that was the theme. The next question out of his mouth, without knowing any of the facts, without any background regarding the plaintiff, the question in voir dire was asked, can anyone here, and here's Miss Chapman right here, and you look at her, is there anyone here that cannot award Miss Chapman $7 to $8 million for her injuries, not knowing what those injuries were? And I'm not exaggerating when I say that 40% of the veneer, and the veneer was roughly 100 people, 40% of them raised their hands and said, under no circumstance can we consider awarding the plaintiff $7 to $8 million for whatever injury she has. That I had a very pro plaintiff judge, and that judge took the position that because they answered the question the way they did, they were disqualified from acting as a juror in the case and were stricken for cause. So I was left with a panel that each one of them said they could consider $7-8 million, irrespective of what the evidence was. And I had basically one hand tied behind my back. I was not allowed to rehabilitate the jury. And again, we were stuck with a very pro plaintiff panel. The jury, the case was tried for 3 days. The plaintiff's evidence was the treating physician, the plaintiff, and the plaintiff's daughter. And the plaintiff's daughter was a moaner and groaner. And it's went to a verdict. The plaintiff in closing had the same mantra. I want $7-8 million to compensate this woman. And the case was submitted on 3 special issues, basically past and future pain, suffering, and mental anguish. We actually tethered and in closing suggested to the plaintiff, suggested to the jury that the woman be awarded $50,000 or $75,000 for each element of damage. The jury came back and awarded, and I'm trying to share my screen right now. The jury came back and awarded Ms. Chapman pain, suffering. Can y'all see my screen?
Yes, we can see it,
Okay.
George.
So these were the issues that were submitted to the jury. And again, plaintiff's closing was award her $7-8 million without tethering any of the elements of damage. All he asked for was $7-8 million, $7-8 million, $7-8 million. We tethered in our closing our suggested ranges to them, because again, in this case, clear liability of between $50,000 and $100,000 for each element of damage. The jury came back at $1.85 million. In that particular situation, the carrier had been sterilized, which is the Texas version of bad faith. We thought we had reversible error in the case based on our inability to rehabilitate the jurors during, or the venire during voir dire. But nonetheless, the case settled shortly after the verdict was rendered. So I think this is just a classic case of an untethered verdict. And again, I hate talking about cases that I lose, but sometimes those are the most destructive.
Hey, George,
yeah,
before you go on to your second case example on that one, if you could have rehabilitated the panel, would you ask something like, those of you that said you couldn't award $7-8 million, if the evidence supported it, would you, or would you be, is that what you would do, or any other thoughts on how you would approach that if you would have been able to do that?
Precisely, Mark, precisely. I mean, I would do an individual voir dire of each juror, and basically go through that line of question. If the evidence supported an award of $7-8 million, could you award $7-8 million? Candidly, probably half of them would say no, but at least I saved half of them and make the plaintiff use their peremptory strikes on them and have a better pool of jurors from which to secure a fair jury.
Yeah, it seems like there should be some response to that. It seems inherently unfair. But here's the other thing I noticed. There's plaintiff counsel trying to throw out $7 or $8 million in front of the jury before they're even impaneled and get that big number out there. Any other thoughts from you, or maybe Dan has a thought on how you would counter anchor or tether that in voir dire? Would maybe you say, well, what if the damages was only $200,000? Would you be able to do that even though they're asking for $7-8 million?
Well, let me let Dan answer that in a second, but I will add this, that all of plaintiff's medical was admitted. None of plaintiff's medical expenses were admitted. Those were limited out. So I didn't have that anchor to go with. All her employment records, all her wage loss records, all of that was limited out, and I was precluded from introducing that evidence to trial. Dan?
Yeah, I agree. And I think one of the questions that was raised in our Q&A goes to that issue of kind of a counter question, which is, would you be able to send the plaintiff home with no money or an X amount of money and a much lower amount? So that's one way to counter that. And you're right, George, the fact that you weren't necessarily allowed to rehabilitate, but just to explore, many of those jurors may have been able to give very adequate compensation, but in a vacuum, and I've seen judges do this frequently, when you give it in a vacuum, they haven't heard the evidence. So a lot of them are just saying, I haven't heard the evidence. How can I say that that's adequate or not? So you have to couch it with, if you heard the evidence and it supports or warrants that, would you be able to do it? And that somewhat attenuates that.
And I think that brings up a really good point too, Dan. And George, why don't you take that screen down and get your other one ready. And I know I'm setting you up by asking questions, but I got to ask you to wrap up in 4 minutes so we can get Elizabeth on. We're going to be pressed for time today. I know an hour is not really going to be enough, but it brings up a really good point that you said, George, that I think everybody has to keep in mind. Build in your appellate issues early and often on this approach. That George, I love your appeal issue of not being able to rehabilitate those jurors and having all those jurors wiped out. My goodness, that's completely unfair, at least seems to me. But go ahead, George, and again, about 4 minutes or so, if you could get through the second example, that'd be great.
Sure, I'll be happy to. Again, the second case occurred in Lufkin, Texas, which is Deep East, Texas. We went to trial in late February, early March. Again, a case of clear liability. Unlike the previous case, the plaintiff did have substantial medical, did have substantial loss of wages, loss of earning capacity, and they sought to recover it all. And I'll just cut right to it. I messed up. When I closed, we tried our case, and when I went to close, I ran out of time, and the plaintiff did not tether their pain, suffering, and mental anguish award to any number, but simply asked the jury to award what was fair. On my rebuttal in closing, I just ran out of time and didn't address it. I addressed what we thought the evidence supported in terms of past and future wage loss and medical, but didn't talk about the hedonic damages. Interestingly, in that case, the jury came back and awarded plaintiff every bit of what they asked for in pain, suffering, and mental anguish. Or I'm sorry, in terms of medical expenses, past and future. And you can see on the screen now the award of past medical, future medical, past wage loss, future wage loss, and zero for pain, suffering, and mental anguish and impairment, past and future. That case is now, we're fixing to file a motion for new trial on that case because the jury award, the answers to the jury questions conflict with one another. How can you have past and future medical, past and future loss of earning capacity, yet not have impairment, yet not have any pain and suffering? So we are actually taking the position in this case that the jury award is not sustainable. What should have happened in this case is that the judge should have sent the jury back to the jury and say, no, you cannot award zero for those elements of damage. But the plaintiff's lawyer asked for the judgment to be received by the court, but the verdict to be received by the court, and the court went along with it. So this is an example of where my mess up and not tethering those types of damages actually help me out.
Yeah, well, yeah, I guess you dodged a bullet on that one, but well done, and a classic example. Any other quick comments, George, before we put it over to Elizabeth, and then we're gonna have a polling question before Elizabeth starts, but any other closing thoughts?
No, I'm looking at some of the commentary, and no, I did not have reptilian tactics in any of my cases. It was purely straight up. So
All
I'll turn
right.
it over to you and Liz.
Thank you, George. Before Elizabeth, before you start your presentation, Lindsay, go ahead and put up the next polling question so that we can all make sure we get our credits. Polling question number 2 is, what argument is most commonly used by defense counsel when trying to convince a judge that the defense should be able to admit medical bills into evidence? First option is jury should be able to consider the bills as evidence of the potential for future damages. Second is the bills are relevant to establish severity and extent of injury. Third option is the bills should be considered as evidence related to a probability or lack thereof that the plaintiff experienced pain and suffering. And the last one is the bills are relevant to the issue of whether the plaintiff suffered anguish over having to pay his or her cost of treatment. And I have a sneaking suspicion that Elizabeth is going to be able to give us the answer to that based on the national review she did and some of the case law that she's come up on. So please fill out polling question number 2. Lindsay, on the side, if you want to send me the result of polling question number 1, if you have a result, I'll share results on these with people at some point if you want to shoot that to me. Elizabeth, you go ahead.
Oh, good afternoon, everybody. I'd love to be able to give you the answer to that polling question. And actually, I'm looking at the results that are now pending, and the majority of our audience was correct. That seems to be the most commonly used argument. So I practice in Oklahoma, and I don't have the level of personal experience that my fellow panelists have. And for that, I guess I'm a bit of a weak link, but I've been tasked with conducting a national survey of what the courts are holding. I started off looking at federal courts, and in my opinion, it seems that they are somewhat split in how they handle the issue and how they rule on the issue. But I am sensing that the plaintiff's bar has a bit of an edge when it comes to federal court. I'm going to start with the Eastern District of Missouri because it's a bit interesting. Back in 2012, the Eastern District of Missouri ruled in a way that the defense bar would consider favorable. There was a case called Hill versus Bikes Truck Line. It's a vehicle accident case where the plaintiff stipulated that that she was not seeking recovery of her medical costs. The defendants in that case argued that the cost of medical treatment was relevant to damage calculations beyond just compensatory damages. The court ultimately held that although plaintiff has stipulated that she is not seeking the cost of her medical expenses as compensatory damages, the court finds that the value of plaintiff's medical expenses may still be at issue in this case. Fast forward to 6 years later, same court, in a case called J.B. Xrel Bullock versus Missouri Baptist Hospital of Sullivan, the court changes its mind. This involved a child who suffered a laceration and went to the hospital for some medical attention. There was x-rays or imaging taken that showed no foreign objects in the wound. The wound was repaired. Subsequently, the child developed some infection and non-healing and went back for additional treatment. And at that time, the doctor that was doing the debridement of the wound discovered a piece of wood inside the wound. The matter went to trial, and the plaintiff withdrew his claim for past medical expenses, asserting that they were not relevant to any issue to be tried. And with the unanchored approach was just saying, hey, we're going forward on pain and suffering only. The defendants argued, however, that the medical bills were relevant to the jury's determination of pain and suffering to show the seriousness of the injury, irrespective of whether the plaintiff has a claim for recovery of the medical expenses themselves. Here, without explanation, this was just in response to a motion in limine, the court just summarily sustained the plaintiff's motion. Same year, same court, in a case called CC through Ginniver versus Suzuki Manufacturing, the court was considering a case involving an ATV where the grip on the handlebar came loose and the plaintiff was injured. The plaintiff asked for exclusion of the medical bills and stated he was not claiming past or future medical expenses, and therefore his argument was the probative value of the bills outweighed was outweighed by unfair prejudice. The defendant argued that the evidence in the bills showed the nature and extent of the injuries and therefore should be admissible. The court found that the cost of medical care has no basis in determining the pain and suffering an individual experienced. So I think what happened in Missouri shows us that via the powers of persuasion that belong to effective counsel, courts can change their minds on the issue. Here in my own state of Oklahoma, in the Western District, in 2021, a matter went to trial where a woman was struck by an automatic sliding door at a Walmart. She went with the unanchored approach and waived her right to seek medical expenses, filed a motion in limine asking that they not be admissible. And the court agreed with her, found them to be irrelevant, but the court actually went a step further and made a firm finding that the introduction of the bills would be unduly prejudicial to the plaintiff. There's a Nevada 2016 case that is not good news for the defense bar. It was an unanchored approach, Campbell versus Garcia. This involved a head-on collision when a vehicle crossed lanes and crashed into oncoming traffic. The plaintiff in that case claimed only pain and suffering, and asked that the court exclude medical expenses, including some monies that had been received for a workers' comp claim that he made. Apparently he was on the job, during this collision. The court there in Nevada ruled in favor of the plaintiff and said because he is not seeking special damages for past medical expenses, there is no relevance between these costs and his purported pain and suffering. There's a case in Montana that I thought is helpful. It was not per se an unanchored approach, but the issue was addressed. It was a products liability case where there was a one vehicle accident that left the plaintiff a paraplegic. The court found with regard to admissibility of medical bills that while amounts of disallowed medical expenses were not relevant to prove damages for past medical loss, medical bills were admissible to show the jury the severity and extent of plaintiff's injuries. And the court further said, bills listing medical procedures performed and treatments dispensed could bear on the necessity of a plaintiff's future needs. I'm going to kind of end our conversation about what I'm seeing in the federal courts with a little bit of an off-color case. This is out of Washington, D.C., a case called Pinkett versus Dr. Leonard's Healthcare Corp. This was an unanchored approach, and it involved a woman who alleged that she sustained injuries from use of a Be Yours Vibe 2 vibrator. She sued the manufacturer and a number of others on several tort claim theories. By the time trial arrived, there was only one defendant and one claim remaining to be tried. She moved to bar the introduction of evidence of the amount of medical expenses she incurred and wanted to proceed on a non-economic damages only claim. The defendant said, hey, the expenses should be admissible as being relevant to proof of whether she was truly even injured. The court there in Washington, D.C. last year said the price tag of treatment does not tend to prove or disprove anything about the nature and extent of injuries, save what it has cost to treat them. This was citing a Nebraska 2007 case. And further said, because plaintiff did not seek to recover medical bills, there is a substantial possibility of jury confusion if the medical bills were introduced to prove a lack of pain and suffering. So that's kind of what I'm seeing in federal courts, in state court.
So Elizabeth,
Yes.
let me interrupt you for just a second. Sorry. I know
Yeah.
you only have about 2 minutes left.
Uh-oh.
But here's what I want. I've got 2 questions for you. First of all, what's the jurisdictional split? Roughly how many courts across the country are saying defendants can't put in the medical specials if the plaintiff waives them? And what percentage of cases or jurisdictions are saying, yeah, the defense can put the medical specials in? So I want to know what the split is. And then the second question is, have you found any unique or particularly good arguments that defense attorneys could make in support of putting medical bills in, even when the plaintiff wants to waive them?
Sure. The split, and I think this probably applies to the state law cases as well, it is, in my opinion, in favor of the plaintiff's bar. And my best estimate is maybe 60-40, 65-35, something in that area. It's a bit of a rough guess because, frankly, there's just not a lot of appellate guidance on the issue. And trying to find state court guidance, it's, looking for a needle in a haystack, which I want to.
By the way, that's in both of my recent trials where this approach was going to be used. I was preparing briefing and exhibits of the medical bills to put in to combat this. And if it was kept out, that would have been one basis for an appeal. Washington and Oregon do not have cases on point to this. Neither does Alaska. So the jurisdictions I practice in, we really don't have any guiding case law yet. It's happening. It's going to happen. But like you said, I guess, Elizabeth, it's about 60-40. There's a split out there of authorities. But what's the best or most unique argument that us defense types could use to try to put in the medical bills when the plaintiff doesn't want them in?
Well, I can maybe think of a couple. One is if they wait till the eve of trial to advise defense and the court that they are not intending to put in their medical bills, go back and look at your pleadings and your discovery. And if it's pled in the petition and the petition is not amended, or if it's disclosed and argued and debated over in discovery and not withdrawn early on, and certainly if it's in the pretrial order, I think you argue, hey, it would be unfair to my client, the defendant, to have to totally change gears right on the eve of trial. And that is reflective of my one experience I had. I was set to go to trial in April, and about 3 days before trial, this is after the matter had been pre-tried, plaintiff's counsel said, nah, I'm not going to admit medical bills. And that was what I was going to argue, is it's throughout the pleadings, it's on the pretrial order. So another argument would be if the plaintiff, this is only if the plaintiff opens the door, but if the plaintiff says, hey, I suffered a lot of anguish over having to face payment of a whole bunch of medical bills. Well, boom, there you have it. I think you argue that the bills are relevant to the claim for anguish. So I know I'm running out of time, so I'm just going to say that with regard to the state court appellate findings, I've found Indiana, South Carolina, Mississippi, Virginia, and probably Georgia are going to have some rulings that are favorable to the defense bar, but Florida, not good. As you said, Alaska, Washington, they don't have any appellate holdings. There's just not a whole lot out there.
So to the panel, or to the people that are participating or observing online, if you want to have a list of the jurisdictions or some of the briefing like this, reach out to Elizabeth, send her an email, and I'm sure she could share that information. As defense attorneys, and that was the whole reason I wanted to do this seminar to begin with, as defense attorneys, we need to elevate our game. The plaintiff attorneys are collaborating on this. They're talking to each other, telling each other how to do these trials and how to do an untethered approach. And the defense needs to get smart about it. The other thing I'd say is what I'm doing now, if I anticipate that there might be an untethered approach, I get the plaintiff's medical bills. I put them in my exhibit list at trial. I'm setting it all up to put them in myself and to cross-examine their experts with it and make sure I blackboard their numbers, which seems completely lopsided. But hell, after COVID, everything is completely lopsided, so why not, right? Before Dan presents next, Lindsay, could you put the last polling question up? And it's a doozy. We had a little bit of an internal debate about this in the speaker's preparation for the seminar. It is question number 3. If you are arguing the case on the basis of no liability, you're saying I want a defense verdict, we're not responsible for any damages, and you're asking for a defense verdict, do you still put up a number for damages? Yes or no? Hot topic, hot question. Dan, I'm going to set Dan up for this, right? Dan's got the answer. He knows what you're supposed to do. I can tell you what I've done, but let's get the polling question done first. If you're arguing the case on the basis of no liability and you're asking for a defense verdict, do you still put up a number for damages or not? What's the answer, folks? And Dan, go ahead. You get started. Oh, let Lindsay. Oh, look at that. We're about the same split. 2/3, 1/3, roughly 72% say yes, 28% say no. By the way, I'm in the yes category. I put up a number. I say we shouldn't have to pay it, but I'm representing my client. If you do find my client's responsible, then you got to be reasonable. Here, let me help you be reasonable. Here's the number, and this is what the reasonable number would be. And by the way I do it in the courtroom is I talk about liability in one area, and when I get to the damage topic, I move completely to a different place in the courtroom, and I set up camp over there and get real low key and talk about damages and say, because they're usually catastrophic cases, like a little kid that gets burned or death cases, really bad stuff. All right, Dan, I can't wait to hear what you have to tell us. We'll get started. We only got 15 minutes left, though.
Yeah, well, thank you. I appreciate it. And you're going to hear this kind of 2/3, 1/3 split because a lot of the percentages kind of fall in line with that. And as you can imagine, as a jury consultant, I've been asked this question many times, and I've been exposed to a lot of different strategies that have been utilized both to accelerate and to mitigate damages. And certainly this phenomenon of the untethered or unanchored verdict has become very prominent. So when you ask people, is this a real phenomenon or is it just kind of a flash in the pan? My response typically is, well, it depends. We hear this expression, perception is reality. And we've seen a lot of different reaction to these strategies and trying to assess, just like Elizabeth has talked about, to get the actual data to see if it's real or not. We've been somewhat challenged. And part of that is because of the inconsistencies in how these verdicts are reported and how the data is collected and reported. So one of the things that we've seen that we'll talk about in terms of the effect of the pandemic is that there has been this anecdotal trend based on data that we've seen more defense verdicts and lower damage awards with plaintiff verdicts. And there's some reasons that we'll talk about as to why that's happening. But when you look at the data more closely, what you see is that it's an artifact of the cases that are being tried and have been tried during the pandemic, which is typically the 1 to 3 day jury trials. And it doesn't include the kind of stereotypical catastrophic injury or wrongful death cases, the bigger verdict cases. So those aren't accounted for like we had pre-pandemic. So part of this that we see is just a function of the verdicts that are being reported. So one of the things that Mark asked me to talk about was, what are some of these key psychological factors or underpinnings that drive these kind of unanchored, untethered trends? And so I'll talk about this briefly. We could spend a lot of time on this, but we know that damage awards may not be rational in the traditional sense, but we have seen that they follow really predictable patterns and systematic rules of reasoning. So one of the things that we know is that of others. And we've found that many jurors these days have become untethered themselves and speak unabashedly. And so there's often a much more candid discussion amongst jurors and how they feel about these issues. We also know that because of the pandemic, there's been an increase in juror perceived vulnerability, or what we call self-victimization. So we know that because of these numerous crises that are happening, including the pandemic, that create crisis fatigue, and so everything from natural disasters to the political unrest, the racial unrest, all of these things kind of come together to create a perfect storm, which has caused an increase in juror vulnerability. And we know when juror vulnerability increases, guess what? Our plaintiffs' lawyers like to use those reptilian strategies to increase that perceived victimization or vulnerability that they take advantage of to increase things like anxiety and punitiveness. So all of these things are happening. The other couple things I wanted to talk about is that we see these use of heuristics or cognitive biases. And Mark, you talked about one of those earlier, but we've heard these concepts known as biases, cognitive biases. So you often hear hindsight bias, confirmation bias, implicit bias is a big topic. But the other two that really come into play here are called representative bias and availability bias. And this is the, when people go to make judgments on damages, what is readily available to them or what seems representative, and that changes based on perceptions. And one of the things that's really been a factor in the research is a psychological factor, something known as GIST, decision-making. And many of you probably read Malcolm Gladwell's books called Blink and Outliers, and it's based on this, what they call System 1 and System 2 thinking. And we know that there's kind of two modes of decision-making. One is this kind of just gut level, instantaneous gist thinking, or the more elaborate, detailed reasoning. So we know those factors underlie these comparative judgments, and we know that emotions then become influential in that. And we know that jurors, based on recent studies, prefer these gist judgments as opposed to numerical. And it's kind of a two-step process, and why these untethered, anchored verdicts really matter. First is that we know that jurors arrive at this, what we call an original gist of whether damages should be kind of low, medium, or high. And that's why those big numbers on non-economic claims become important, and why they want to dispense with comparatively lower numbers on economic, because we know that people make these just judgments and kind of categorize low, medium, and high. And then they translate that into a more specific number. So we know that the gist of severity of a plaintiff's damages and a defendant's liability will often predict those damage awards. So just quickly, a couple of things that's interesting to note here is why this untethered verdict is interesting, is because we know that these initial gists tend to be more reliable and more consistent than specific verdict numbers. So for example, if 500,000 may be high in a vehicular injury case, but that same amount would probably be low in a long-term environmental damage case or a wrongful death case. So what's interesting is that jurors' evaluation of the magnitude of those damage claims can be affected by how precise the number is. And research shows that precise numbers are perceived as lower than round figures. So what may be interesting is that it's more effective to suggest a round number for that alternative damage theory. That anchor is to suggest a round number. And so the second thing is that jurors' assessment of the difference between what the plaintiff's damage request is and, say, a defense's alternative damage number is influenced by what is called the left digit anchoring effect. And people may have seen this, is that people will focus on the left digit when making judgments in magnitude as comparison to other numbers. So for example, the difference between $4 and $2.99 is perceived as greater than the difference between $4 and a penny and $3, even though the delta is the same. So the implication for this, and this is why it goes to this anchoring effect, is that if the left digit is as close as possible to the plaintiff's figure, studies have shown that that number appears more reasonable and less likely to be seen as a lowball figure. So that's this kind of psychological underpinning is interesting. And so when jurors go to evaluate damage figures differently, depending on those numbers that they may have already heard, that anchor number, after they hear a large number, even if it's subliminal, a plaintiff's damage request can then seem lower or more reasonable.
Just a sec, Dan, I got to interrupt you. I'm fascinated by this. Give me a real life example. I'm going to give you the parameters. Let's say the plaintiff's going to ask for $6 million, and it's a case that maybe we think legitimately is worth 200,000 or 300,000, something like that. Okay, and they ask for 6 million. Okay, what's the defense number that you're suggesting to counter that 6 million to the left digit number?
Well, for example, instead of offering 2,999,000, 3 million and $1 is going to seem more reasonable and less like a low ball than the 2,999,000, even though it's only $2 difference.
So it's just one side of the decimal point.
Exactly. It's that left anchoring effect that happens there. So, the recommendation is that, at trial, the council has to speak to the gist as well as to specific numbers and use meaningful anchors. And so there's a lot of fun studies out there that have been conducted that tap into this, but
so Dan, we only have 5 minutes left because we
Yeah.
cut it off at I guess noon Seattle, 3 o'clock Eastern time, and whatever time zone George is in Cancun. So we got 5 minutes. What have you seen to be some effective techniques or strategies to combat this unanchored approach? And before you do that, tell me, I actually did this in a trial, but I want you to tell me whether it's a good idea or not, because I actually don't know. It worked out okay, but I'd sure like to know if this is typically a bad idea. But in voir dire, I suspected they were going to use an untethered, unanchored approach. So in voir dire, I had a couple people with some psychiatry and psychology history or background or experience or classwork. And I said, does anybody know what anchoring is? And we just had us a good old discussion about anchoring and talked about what it is and why it is. Oh, the psychologist guy, he couldn't wait to tell everybody. I made him wait and asked other people, made them talk. And then I got, Mr. Smith to come in and tell us what it really is. I knew Mr. Smith was going to get dinged off that jury anyway, but I used him to educate the rest of the jury. Good idea, bad idea? Is that?
Yeah, it's a great idea. And that was one of the key strategies is that you have to alert prospective jurors to those biases, whether they're hindsight biases, confirmation bias, implicit, whatever, anchoring. It's best to deal with that and address it early on.
Like voir dire or
absolutely,
okay.
Right from the get-go in voir dire.
I'm not sure you can do that in opening. You can probably do it in closing, but I'm not sure how opening discussion about that's going to be.
Yeah, it really varies depending on the jurisdiction and the judge, for sure. And a few other quick things that we've found is really effective techniques. First and foremost, you have to know your audience and test your narrative, and understand what is it that makes jurors angry, so that you can condition the veneer and deselect those high-risk jurors. So, use those reptile words in jury selection. Talk about safety, danger, unreasonable risk, safer, protection, community. Those are all buzzwords that we hear, but we also have to lead with compassion and talk about responsibility and accountability. And that comes through not only in the introduction, but as trial to humanize the defendant, right, the corporation, and to prepare your storytellers, your witnesses, so that they can reset expectations and really extinguish some of those fears where we talk about reasonableness, industry standards and the like. And finally, talk about giving an anchor. And as you said, the studies have been mixed over the years, but consistently, they have found that if liability is highly disputed in a close call, providing a counter anchor is a very effective strategy. Studies show, however, if liability is not a close call and is pretty clear in favor, leaning towards the defense, that providing a counter anchor is not necessary. And so, again, it's interesting studies. One quick one is that the defendant in these studies offered a counter figure, and it didn't impact liability, but it reduced the overall award by 43% versus just ignoring the damage number. And interestingly enough, it reduced it by 76% compared to someone who had just purely attacked the plaintiff's number but didn't offer one of their own. So if you're going to attack, you have to provide a counter anchor, and that's, I think, a good strategy.
And Dan, speaking of numbers, not the number that we're done in 1 minute, but I want to give everybody another idea. I did this once, and I'm pretty sure the plaintiff bar in Washington is now going to bring motions in limine against me doing this ever again, because it worked out really well. But the plaintiff attorney didn't reference numbers in opening. And I talked about our case and what we're going to show. And then I said something like, I knew they were going to ask for, I can't remember what it was, 10 or 20 million, something like that. And I got done and I said, now it's possible, folks, that they might ask for, like, they might even ask for 2 or 3 million. And I made it sound like a really big number. And you could, and it was too late. Plaintiff couldn't rebut that and say, oh no, we're gonna ask for 20 million. And then when we got to closing and when they said 20 million, you could almost hear an audible gasp from the jury thinking, oh my goodness, that's so much money, so ridiculous. So like I said, that one turned out okay. I don't know if that's a legit way to counter anchor, but you know, approaching it, but warning the jury that, hey, they're going to ask for something stratospheric that has nothing to do with anything. Okay,
Yeah,
15 seconds, Dan. Any last comment?
Just, you know, rely on your common sense. I think a lot of people forget about their gut instinct and common sense. These things that we hear and learn about, apply them. They do work, they're effective strategies, and go out there and be productive.
Well, thank you for being with us, Dan, and Elizabeth and George. Can't thank you enough. George, thanks for cutting off the margaritas and joining us from the waiting room in Cancun and during your vacation. But thank you all. Appreciate everybody for attending. And that's the end of the seminar. Bye, everybody.
Ron.